Did you know that under the Fourth Amendment, cops can use even the tiniest traffic violation as an excuse to arrest you, impound your car, and search your car, all without a warrant? But what happens when those rules are twisted as a cover to dig for evidence? Evidence like a locked gun safe. As a former prosecutor turned people's lawyer, I'm going to break down for you exactly how far cops can go to open up and search a locked gun safe. In fact, in this video, I'm going to cover two different scenarios. Scenario number one is when a police officer pulls you over for a traffic stop, which leads to them wanting you to open your locked gun safe. Then scenario number two is what if cops show up at your house, maybe with a warrant, and they begin searching around your house? Does that allow them to also search your gun safe? Meet Mark Johnson and Leo Jim, two men who were arrested and their cars were impounded for safety reasons. Police claimed they were just taking inventory of their belongings. But when drugs, cash, and even a locked gun safe were found, it became very clear this was anything but a routine inventory. In fact, it may have been a deliberate search for evidence. Here's the loophole. Police are technically allowed to search your car if after they arrest you, they decide they are going to tow your vehicle. Or maybe you're committing a different type of traffic violation like blocking traffic. But these inventory searches are technically designed to protect your property, not collect evidence. Mark Johnson's case exposed this flaw because police actually admitted they were specifically looking for evidence rather than an inventory. And in Leo Jim's case, his locked gun safe became the key that saved him, primarily because of his state's constitution. Here's the critical flaw. When police officers take inventory searches too far, your rights are at risk. Nearly 50 years ago, the United States Supreme Court in South Dakota versus Opperman, they legitimized what is known as an inventory search. An inventory search essentially allows a police officer to dig through the entire car and inventory it. Literally, write down all the items in an effort to supposedly protect you and your property rights. But really, this is nothing more than a Fourth Amendment exception. But why exactly do we need this Fourth Amendment exception? Well, I'm going to read to you what the Supreme Court said in the Opperman case. They said, quote, "These procedures are developed in response to three distinct needs: the protection of the owner's property while it remains in police custody, the protection of the police against claims or disputes over lost or stolen property, and the protection of the police from potential danger." So the court gave us a three-part test to determine if there's a valid inventory search. Number one, the vehicle must be lawfully in police custody or control. Number two, the inventory must follow established procedures of the police department inventory policy. Then number three, the search must be reasonable. Later, in the case of Colorado versus Bertine, the United States Supreme Court tried to give us more specifics by saying, quote, "A warrantless inventory search and seizure might be invalid if the accused can show the government action was in bad faith or for the sole purpose of investigation, a very high bar." What does that mean? What exactly are the limitations to police performing these inventory searches on all of us? The number one thing you have to look at for an inventory search is we have to take a look at whether or not the police followed a standardized procedure according to the police inventory policy. In fact, in the Bertine case, the Supreme Court said that the police department must have a written policy and it must guide the officers with limited time and experience. It must guide them with exactly what to do in order to perform the inventory search. In fact, in the Supreme Court case of Florida versus Wells, the court ruled that a search of a locked suitcase in the trunk of the car was unconstitutional. And I want to read to you exactly what they said. They said it was a violation of the Fourth Amendment because, quote, "The Florida Highway Patrol had no policy whatsoever with respect to the opening of closed containers encountered during an inventory search. And absent such a policy, the instant search was not sufficiently regulated to satisfy the Fourth Amendment." But federal courts across the board have broadly upheld inventory searches where police have written policies and they follow those inventory policies. So the very first question I ask anytime I see an inventory search is, I want to know, does that police department have a written inventory policy? And did they follow it to the letter? If that police department who conducted that inventory search does not have a written out policy, and if they did not follow that policy to the letter, it is an illegal search under the law. But wait a minute, What about cops finding a locked gun safe in Leo Jim's truck? Will the Fourth Amendment protect him here? Under only looking at the Fourth Amendment analysis alone, an inventory search of a locked gun safe in a car is not a violation of the Fourth Amendment as long as the police department has a specific policy and they followed it to the letter of the law. If the police were doing an inventory as a way to disguise a criminal investigation, that's a totally different story. The problem here, it's very difficult to get courts to believe your argument. Why? Because courts make you bring the evidence to prove that the reason that the police were searching your vehicle was not because of an inventory, but instead because of an investigation. Now, this is not impossible to pull off, but it is very difficult. This brings us to United States versus Johnson. In that case, the police were actually staking out Mr. Johnson, and instead of just arresting him where he was in his residence, they waited for him to get in his car and to drive where they could actually box him in. They stopped him in the middle of the road and surrounded him with patrol cars. Cops then approached Mr. Johnson with guns drawn, making it impossible for Mr. Johnson to move his vehicle out of the middle of the road. This so-called traffic violation of leaving your car in the middle of the road was the reason the police now decided to perform an inventory search of the vehicle. The court found that the primary reason the police did all of this from the very beginning was to investigate criminally Mr. Johnson. So as a result of that, they threw out that search as being an illegal inventory search. But not all courts will give somebody the benefit of the doubt in this situation. In fact, the only reason that Johnson won his appeal is that the police mistakenly labeled all of the items in the inventory search as evidence. So as a result of that, the courts looked at that and said, wait a minute, you seized all of this as evidence, not as an inventory, so we will determine that is an illegal search. Now look, here's where it gets really interesting. Some states in our country provide you more Fourth Amendment protection than the actual federal Fourth Amendment protections. So as a result of that, this is known as the interstitial approach. This particular approach means that your state constitution provides you more constitutional protections than the federal constitution does. It really matters where you live. Because if you live in a state where your state Supreme Court, your courts of criminal appeals provide more protections than the United States Supreme Court does, then you're going to have a different answer to this question about whether police can search a locked gun safe during a traffic stop. With Leo Jim's case, he lived in New Mexico, and New Mexico happens to be one of these states that provides you more constitutional protections under the Fourth Amendment. Thankfully, the federalism provisions under our Constitution allow 29 states currently to provide you more privacy, more Fourth Amendment protection than the United States Supreme Court will provide. But if you live in one of these other states that provides you no additional protection and you're only relying on the Fourth Amendment, now you have to understand police, if they have a valid inventory policy, and if they follow that inventory policy to the letter, they can now take your locked gun safe out of your vehicle, inventory it, force it open, and now you've lost your privacy rights, and it's a legal search. We've been covering how to handle cops when they want to search your gun safe. But if you're like me, you want ultimate privacy from the government and from bad actors when it comes to your data. This is precisely why I use Nordvpn to provide me the ultimate solution to both privacy and security. One of the key benefits of partnering with Nordvpn is that they actually make sure that your internet traffic is encrypted, ensuring that your sensitive data is safe from hackers and online snoops. Whether you're on public Wi-Fi or just surfing the internet at home, you can rest easy knowing that you are protected. Now, here's the best part. Nordvpn is super easy to use. With the click of a button, you can connect to the fastest servers available so that you can have lightning fast internet without sacrificing your security. As a bonus, with thousands of servers in over 100 plus countries, Nordvpn allows you to access your favorite content from anywhere in the world. So if you want peace of mind while surfing the web, Nordvpn has been kind enough to offer a special discount for only our viewers. Get Nordvpn 2-year plan plus 4 months extra. A special discount not found anywhere else. Click on the link that you see here on the screen down in the description or in the pinned comment. Plus, it's risk-free with Nordvpn's 30-day money-back guarantee. Click down in the description and get the link below and get this special offer from Nordvpn and get started today. Now, back to what to do if cops are looking to search your gun safe. In this case, because Leo Jim lived in New Mexico, and he realized that his state of New Mexico provided more privacy and Fourth Amendment protections than federal law, all he had to do now is look at his state constitution and point to the provisions that provide more protection so that this could be deemed an illegal search. Specifically, he argued that the inventory search was unreasonable because it intruded upon his reasonable expectation of privacy for the contents inside the locked gun safe. In fact, under New Mexico Constitution, Article 2, Section 10, the court is required to, quote, balance the need for the search in a particular case against the intrusion upon the individual's privacy interest. Here was the ultimate question. Was the need to search a locked gun safe important for an inventory when the contents were going nowhere compared to the infringement of a substantial privacy interest? This is so important for you to know for your state because New Mexico has two important distinctions, very different than federal law. Number one, there is greater protection for your privacy within the context of a car, an automobile. And then number two, there is a very high preference for cops needing to get a warrant anytime there's uncertainty. I wish all states did this, but the one great thing is New Mexico says that what you have in your vehicle, it's very private. It's very important to you. So you have a higher standard and expectation of privacy for the items within your vehicle than the federal Constitution provides. In fact, even though the United States Supreme Court has very much minimized your privacy rights when it comes to items inside of your car, the New Mexico Constitution and New Mexico case law has said that you have an expectation of privacy and, quote, a routine policy inventory of the contents of an automobile involves a substantial invasion into the privacy of the vehicle owner. That comes from a New Mexico case law known as State versus Nimrod. So very important to understand. There are greater rights that you have in certain states than you do under the federal Constitution. With that being said, the New Mexico court ruled that Leo Jim's locked gun safe in his car, his truck, was sufficiently protected by the fact that it was in a safe and that it was already under lock and key. Think about it here. Once the officer takes the gun safe and maintains it in police custody, there is little to no risk that anyone's going to steal it or break into it because it's a safe and the police have the key. Not to mention, the police had plenty of opportunity to get a warrant here, but they just didn't want to. They wanted to seize it and open it as quickly as they could. Because the court came right out and said there was no emergency circumstance here. You were sitting on the side of the road. You had a safe. There was no chance that any evidence was about to be destroyed or anything strange happening here. So all they had to do was go get a warrant and they could have opened it legally. So when you combine these two issues, the New Mexico court ruled it was an illegal search. But it really comes down to what state you are in. Because otherwise, if you're in a different state, many other states are going to allow a police officer to pull you over for some ticky-tack reason. They can use that ticky-tack reason as a pretext to arrest you and then do a full inventory search of your car and use whatever they find against you. Scenario number two, what if cops show up at your front door now demanding to search your gun safe? How do you protect yourself here? First of all, never consent to a search. And this is really important, because I have seen people consent to a search where they tell an officer, yeah, you can come in and I don't mind you searching this room over here. And then when you consent to one thing, cops interpret it as something else and now they're searching everything. How do police get away with this? This brings me to the case of Florida versus Jimeno. In this case, the Supreme Court ruled that the scope of your consent is determined by what a reasonable police officer would believe they thought you meant when you gave it. In other words, if you consent and you're not clear about what you consent to, there's a good chance cops are going to interpret that as you consented to everything. So never consent to a search. In fact, if the cops come to your front door, you don't even have to answer the front door. But if you choose to do so for whatever reason, remember, you can say, "Officer, I refuse consent to search, and I exercise my right to remain silent and will only answer questions with my lawyer present." But what if police come to your front door telling you they now have a warrant? In that situation, police can legally enter your home based upon a valid warrant. But you always have the right to ask for a copy of the warrant, and you need to make it crystal clear to the officer that you do not consent to any other search beyond the scope of the warrant. because you want to make it clear at no time do you authorize that police officer to do anything more than the warrant provides. Oh, by the way, you also have a right to record the police during the entire search, because sometimes what ends up on a police report may not be exactly what you remember taking place. So if you record the entire experience, you'll have evidence to establish if everything went down properly. But what if they do have a warrant and they start searching your house and now they find a gun safe? Can they demand you open it? When a police officer shows up with a warrant, we need to actually take a look at what the warrant says. What is the scope and focus of that warrant? For example, I knew a case one time where the actual warrant itself, the search warrant, was all about looking for a motorcycle, right? So if they show up, they could look on the outside of the house, around in the garage, looking for this motorcycle, and technically they could look inside the house for this motorcycle. But then they wanted to go to a locked gun safe, and now, can they really look in a locked gun safe when a motorcycle will not even fit in a locked gun safe? In that situation, many courts would hold that as being an unreasonable search because it exceeded the scope and focus of the warrant. But if instead, maybe they were there looking for certain documentation, now that makes a lot more sense because it would be seen as a reasonable search because those items could be found in a locked gun safe. So how do you protect yourself in this situation? Number one, to stop cops doing this, do not consent to the search. That's the best way to protect yourself. Number two, know your state laws and your state constitution. You need to know if your state laws provide you the extra privacy protection that the United States Constitution meant for you to have all along. Or you need to be aware that if you live in a state without these extra protections, you have very little privacy interest for either the interior of your car or any of the locked containers within your car. Now, speaking of privacy rights and Fourth Amendment protections, we just covered when a police officer can search a locked gun safe. But how do you protect yourself from a police officer now trying to open and search your gun case? Check out this next video where I walk you through how to stop cops from searching your gun case. See you over there.